Have you ever heard the news of the member of legislatures or member of parliament resigning from their political party to join another political party? If you have heard the news, then you are close to knowing what defection is. Defection is the act of leaving one's own political party and joining another party. The Anti-Defection Law or the disqualification of members of legislature or parliament is mentioned in the 10th schedule of the Constitution. The Anti-Defection Law states that if a member of parliament or member of legislature voluntarily gives up the membership of the party or votes or abstains for voting or defies any party whip or joins any of the other party, then the member will be disqualified from the party and he will not hold the position of a nominated or an elected individual under the party. Thus, he will lose his position as an MP or an MLA. The 10th schedule of the Constitution was added by the 52nd Amendment in the Constitution in 1985. The Article 102 Clause 2 and Article 191 Clause 2 are the other two provisions in the Indian Constitution which states that the legislators can be disqualified if they are disqualified under the 10th schedule. Now let's see what is the need for the anti-defection laws. There was large-scale defections in the years 1960s to 70s. There was also an instance in the year 1967 when Gayalal, who a Congress leader, went from Congress to Janata Party and then back to Congress and then again to Janata Party in just 15 days. A member can also be disqualified if he was an independent candidate but he joins the party after the election, or if he is a nominated member and he joins a party 6 months after he became a member of the legislature. The chairman or the speaker of the house has been conferred with the power to take the decision to disqualify a member. But if a complaint is made with respect to the defection of the chairman or the speaker itself, then a member of the house elected by that house shall have the right to take the decision. Well, there is an exception to the disqualification. A person shall not be disqualified if his original political party merges with another political party and he, along with other members of the old party, became the member of the new political party. Or the members can also opt out and form a separate group if they do not accept the merger. This exception shall operate if only not less than 2/3 members of the party in the house have agreed to the merger. Now, let's look into the issues regarding the anti-defection law. The first and foremost issue that needs to be addressed is whether the 10th schedule curtails the right to freedom of speech and expression. In the case of Quixoto Holohan versus v.zachilhu and others, the Supreme Court stated that the democratic rights of elected members of the parliament are not infringed. The second issue raised is that if only resignation can constitute as the voluntarily giving up of membership and affiliation from a political party. The Supreme Court has settled this issue in the case of Ravi S. Naik versus Union of India. It has held that the phrase voluntarily giving up membership has a wider meaning and even the conduct of the members can come under the ambit of this phrase. The Para 7 of the 10th schedule puts a bar on the jurisdiction of the court in respect on disqualification of a member of the house. This is against the basic structure doctrine which was put forward in the case of Keshavananda Bharati. Thus, in the case of Quixoto Holohan versus v.zachilhu, the court said that the Supreme Court and the High Court has the power to review the decision made by the Speaker.
Stay safe and stay healthy. Sincerely, from yours lawfully. Thank you.